What's the average time it takes to obtain an international design patent? It's a very specific question. I will say there is no such thing as a single international design patent. You do have to register them in each country, just like you do on the trademark side, right? But what's cool is there are treaties set up on the utility patent side. It's called the Patent Cooperation Treaty. On the design side, it's the Hague Agreement, HAGUE, for industrial designs. And it's the way it works is you submit an application naming your home country, and then one examiner will represent the whole world or those that have signed on to the treaty, and that part saves you time and money, not having to do the search costs at each country. Assuming it's novel, then you can proceed to file. Maybe you need to convert the application, follow the specific rules of the country, maybe get a hold of a local attorney in that country to file it and follow their specific rules. But yeah, that's the path. In terms of timeline, design patents are a whole lot faster than utility because design patents are really, for the most part, about the drawings. Yeah. And there's a lot less to fuss about. Don't get me wrong, some of them are, quite particular and can take a while, but I would say a year to 2 years, to get some rights within, internationally. Depends on how many countries, of course, but I hope that helps answer that. Trademark-wise, international, are some other countries faster now than the U.S.? I mean, what are some issues there?
All of them. This is not great. I was just looking at it. I had to email a client today some bad news about we had to refile for a trademark application for a variety of reasons. But yeah, it's frustrating. There's a lot of young examiners out there, the USPTO right now, which is great. It's just maybe a little bit more mentorship. Maybe someone should be looking over their shoulder before they issue all these crazy office actions. So
yeah, and they're supposed to be attorneys. In fact, they are.
Yeah,
they passed a bar exam. I'm sure.
They're all very smart people, but for whatever reason, like a lot of times, logic doesn't seem to make a lot of the logic doesn't apply at the USPTO sometimes. So like I'll just give you a quick example. I mean, I'm trying to make it as quick as possible. We had a client, not a bold, but we had a client basically that had to refile the trademark application. We took over the trademark registration. It's time to renew the trademark. The application was filed too broadly. So we got dinged basically for having to bring the application back in smaller. They had a lot of products that they weren't actually selling. Eventually, the USPTO said this trademark is basically dead. We don't think that you actually went to market with any of these products. So we had to refile the trademark application. But, the client's been around for the last 15 years.
Crazy.
Well, while our trademark was registered, another trademark under a similar name was registered as well. USPTO didn't catch it. So that trademark registers. We file a new trademark application. But before we file our trademark application, another trademark application is filed for a similar name.
Oh, no.
That application is allowed to register. The third-party trademark that was filed during our old trademarks time period was not cited against it. Our client comes along, we refile the application, and now both applications, one registration, one application, are cited against our client. It's like, no, that makes no sense, right? So anyways, that's the logic you get at the USPTO, but, they don't care. They don't want to hear it.
That's a mess.
That's the problem. It's just not fair, right?
And the business owners pay. They have to hire you to do.
Because I'm going to have to cancel the one registration now because they won't talk to me. The third party won't respond. Yep. And we're going to have to oppose this other application now too. And neither of these third parties are from the United States. So it makes dealing with them a lot harder.